So, good afternoon, everyone. Welcome to the second Belgrade Legal for this school year is Izabela Skoczen. Izabela Skoczen is a researcher at the Jagiellonian University in Krakow. She's a member of the Guilty Minds Lab in Switzerland and Jagiellonian Center for Law, Language and Philosophy. Her research interests include experimental jurisprudence, which will be one of the topics of today's lecture, cognitive science, philosophy of language, and philosophy of law. In 2019, she published a book, Implications of Legal Language, for the Springer Law and Philosophy Library. And title of today's lecture is Experimental Jurisprudence, Lying versus Perjury Distinction. And I have to say that it is our great pleasure to have her here today, because this is the first time that at the University of Belgrade, experimental jurisprudence is a topic of academic lectures. So we are looking forward to hear a lot of new things and to start a series of lectures on this topic. And because of that, I will just give a quick introduction. So experimental jurisprudence is an emerging field of legal scholarship phenomena through psychological investigations of legal concepts, and the field departs from traditional analytic legal philosophy and its ambition in its ambition to elucidate common institutions in a systematic fashion, employing the methods of social science. So, but Isa will tell us more about this. So Isa, I give a floor to you.
Many thanks for this introduction and many thanks for the invitation. It's really an honor to be able to present here. So I'm going to try to share my screen now. I can't share my screen. I think you need to change my status.
Yes, and I just did it. Now you're a presenter, so now it should be fine.
Okay, it's working. So the topic is experimental jurisprudence, the lying versus perjury distinction, but I would like to do it in like a two-step fashion. So first I would like to say just a little bit more about what is experimental jurisprudence and why do we need it. And then, as that may seem a little bit abstract, give a concrete example so that you can see how this experimental jurisprudence new program can be useful to also old problems in legal philosophy and legal theory. So what is experimental jurisprudence? To like understand why we need it, I think I should start with like a super short introduction on what is experimental philosophy. So experimental philosophy is defined as something which is supposed to supplement, not replace, but supplement traditional analytical philosophy, especially conceptual analysis. Now, why do we need this supplementation? So there's a lot of discussion about conceptual analysis saying that, well, it's often sort of a little bit not in touch with what people think. So not in touch with what are the folk views on concepts or on meaning. And I'm thinking very hard about some hypothetical scenarios in an armchair might be useful for normative thinking, but it needs to be based on like an adequate picture of what people think and what people's intuitions are about some experimental scenarios. And so the metaphorical idea of experimental philosophy is, well, let's burn the armchair, not only sit in the armchair, but go and talk to the people, right, and see what their views are, so as to stop a potential speculation about what people's views are, because speculation might be wrong and inaccurate. And this is especially pertinent in quite common situations in debates in analytical philosophy, where one group of philosophers say, well, our intuition or my intuition about what most people would say in response to a philosophical dilemma or in response to a question about the meaning of a word is A, right? And another group says, well, my intuition is that they will say not A, right? That they will have a different answer to a dilemma or a different answer to a question on the meaning of a word. And these are situations where, you know, often like the answer is sort of crucial to the theory in conceptual analysis or analytical philosophy, which is being built. So we really don't want speculation. We want to know, right? What is the folk view or the psychological picture of the problem. And experimental philosophy is this project which is supposed to help. So this is a project which allows us to use this new state-of-the-art technologies that we never had before, but we have them now, and we can resolve this questions about who is right about what the folk thinks. And we can check it. So we can check it using the methodology of psychology, sociology, statistics, and mostly massive surveys online, right? So we can ask people online about what they think and see if there are statistically interesting differences in their answers. But it's not only limited to massive online surveys. You can also use corpus studies, which are studies involving a massive body of text, for instance, where you can see how people use a word, for instance, in all the newspapers that have been published in a country for the last 10 years or something like that. There's also a neuroscience method which are being used, like fMRI, to see, for instance, how people process language, or VR studies to try to make people take decisions in moral dilemmas, and so on and so forth. So using all this new stuff that we have available to make our conceptual analysis and our like theories in analytical philosophy even better than they were before. So it's not a project of replacing, but a project of supplementing. And now, why is it especially useful for lawyers? So why is there all this like hype about especially experimental jurisprudence, so experimental philosophy of law? Where in the law, a lot depends on this folk views and folk concepts in many areas of the law. For example, so if we take Kevin Tobias' paper, he lists just a couple of examples. So law often relies on many concepts that also appear in ordinary life. So for instance, did someone exercise reasonable care? What caused the outcome? Did somebody intend an action? What was somebody's motive? Was there consent in an agreement? What is the text's meaning? And all these concepts, even if they are defined in the law, even if they have technical legal definition, they're also used in ordinary language, so they also have an ordinary meaning. And it can be both interesting to find out what this ordinary meaning is, and the folk concept, but it can also be interesting to see if the folk concept, for instance, influences us in deciding whether something falls within the scope of a legal definition. So if we can really understand this legal definition and apply it, or do we rather tend to use, even maybe unconsciously, this folk concept, which might be different than the legal definition. And it's important, of course, in common law countries where juries often decide what the meaning of, I don't know, intention or cause is. Some legal systems even delegate to the folk a decision on the meaning of that word. But it can also be interesting for civil law systems for many reasons. Also because we often need to interpret in accordance with the ordinary meaning and know what the ordinary meaning is, and also know how experts reason, whether they reason in accordance with the assumptions made by the legal system. So experimental jurisprudence is something that supplements traditional philosophical methods with empirical methods to understand how lay people and experts understand the law. For example, to fully answer the jurisprudential question, how does a legal concept differ from the ordinary one, it is helpful to more fully understand the features of the ordinary concept. The cognitive science of ordinary cognition can contribute importantly to this jurisprudential inquiry. And why is all this useful for lawyers, comparing these full concepts and technical concepts, where we can check whether we indeed follow our preset rules and principles? And now I know that it sounds abstract, but there's many implementations of this. So for instance, most of the criminal law codes, and it doesn't matter if these are codes which are in the common law or in the civil law, state that responsibility for attempts should mirror responsibility for perpetration, because the attempter is just as dangerous as the perpetrator, right? They create the same risk, they have the same mental state, and so on. But if we, for instance, notice in case law that perpetrations are systematically punished higher, or people are held responsible more often for perpetrations than attempts, well, this project can help us find out why is it so, and we can see whether people reason more in accordance to the mental state or more in accordance to the consequences. And for instance, we can see that instead of looking at the mental states as the law suggests, they look at the consequences, and these consequences drive their judgments through, for instance, emotions such as blame, right? In case of perpetration, you have a bad outcome, well, then you tend to blame more the perpetrator and then hold him more responsible than the attempter. And there's tons of papers in this and tons of research on this. This is just one example that I wanted to mention, and it all sort of stems from this idea that was born, let's say, in economics and psychology. I guess the most famous fathers of this idea are the Nobel Prize receivers Amos Tversky and Daniel Kahneman, who said, well, we as people assume some rationality rules, right? And then we want to act in accordance with these rationality rules, but sometimes we fail, and we are not always aware of the fact that we fail. But it's important to be aware when we fail, because in the law, for instance, this can lead to injustice. And this experimental jurisprudence project is supposed to track down these irrationalities and these potential biases in legal decision making, also to make the law more fair and just for all. And this is like a very abstract and general description of what this experimental jurisprudence project is. And I'm not even like trying to list all the sub-projects which are there, because there's really a lot of them. I'm just going to give one example that I've been working on. So as a distinction between lying and the legal definition of lying in the courtroom, which is called perjury. So there's a lot of research in experimental philosophy on the full concept of a lie. So what do people think is a lie? And this research finds that this concept is much broader than philosophers thought. And my hypothesis is that there is a divergence between the full concept of lying and the statutory definition of perjury, which leads to an overcriminalization. So we have good ethical reasons to make the statutory definition narrow, but for instance, lay juries tend to neglect this legal definition and judge or reason in accordance with this broad full concept of a lie, which can potentially lead to an overcriminalization. Then I'm going to present some experimental results which support this hypothesis and try to model jury ascriptions on perjury. Now, this is, of course, only one experiment, but there's many more. So if you are interested, I'm happy to send you more on that. So this whole discussion of the legal definition of lying started with a very, very famous case that went to the United States Supreme Court and really influenced thousands of perjury cases, not only in the US, but in many other countries. So the Bronson versus US case. So Samuel Bronson, whom you have on the right-hand side, was a filmmaker, the owner of Samuel Bronson Productions based in New York, and he made films in various countries to lower the movie production cost, and he kept bank accounts in all of these countries. And then he made this movie, The Fall of the Roman Empire. You have the poster here on the left-hand side, and this movie proved to be a financial catastrophe. And so Bronson filed for federal bankruptcy protection, and he was questioned and under oath by one of the lawyers representing his creditors about like his offshore bank accounts. And the following super famous exchange ensued. So he was asked in courtroom, "Do you have any bank accounts in Swiss banks, Mr. Bronson?" And he said, "No, sir." And the lawyer asked him, "Well, have you ever?" And he said, "Well, the company had an account there for about 6 months in Zurich." And what this answer suggested, though it didn't explicitly say it, the answer suggested that, well, he personally had no bank account in Swiss banks. But it turned out that he did have a personal bank account in a Swiss bank. And the question was, well, did he commit perjury? So was it a willful lie in the courtroom or not? And the lay jury said, yes, sure, it's a lie. But the Supreme Court said, wait, no, this is not perjury. This is not the legal definition of a lie. Why? Why did the Supreme Court judge differently than the lay jury? Well, for two main reasons. First, there's a duty of the lawyer to inquire further. So no one has a duty of self-incrimination, right? We have good ethical reasons why the criminal procedure is shaped as it is. It has been shaped through many, many years of refinement, and we want to keep it to protect the witnesses who arrive in the courtroom, are often stressed, are there for the first time, and so on, and they really need to be questioned by the lawyer rather than have a duty of self-incrimination. And second, given one in a courtroom context, one should refrain from drawing any implications. So one should not draw the suggestions, the implications from what is being said. One should only consider what is being explicitly said. But does one refrain from drawing implications? Like, is it possible to switch off this thinking about what are the suggestions that stem from what is being said? So the hypothesis is that the full concept of lying, which is broader, right, encompasses this false implications, this false suggestions from what has been explicitly said. And this is why lay juries do not follow the stated. And this is why, like, the lay jury said, well, this was a lie, even though it did not fall within the scope of the statutory definition. And there is a lot of research in experimental philosophy about lies. And there is like one robust study by Alex Wigman and Louisa Hines, who like really tested many different scenarios and many different types of these suggestions from statements. And they find that the suggestions from the Bronston case, so the GCI type suggestions, are very often found by people to be lies. And what predicts best as judgment is the notion of commitment. So the more one is committed to what one is saying or suggesting, the more one is judged to be a liar if the suggestion turns out to be false. And another notion which predicted nicely these lying judgments was the notion of deniability. So how likely you are to later to deny having suggested something. If you can deny it, well, then you didn't lie. But if it's very difficult for you to deny later that you suggested something, then you are likely to be judged a liar later. I also did a lot of research on that, and I found that it's often the case that the more we trust someone, the less we blame this person for suggesting something false, and the less we find this person to be a liar. But the less we trust a person, the more we blame that person, and the more we find that person to be a liar. So it's sort of inversely proportional, this trust and blame relation, and also predicts, well, when people will say that something was a lie and when something was not a lie. So does the full concept of a lie affect this perjury ascription, so this willful lies in the courtroom? The statutory definition, this is the US statutory definition, but other definitions are similar. They have very similar criteria. Says that if any person lawfully sworn as a witness or as an interpreter in a judicial proceedings willfully makes a statement which is material in that proceedings, which he knows to be false or does not believe to be true, shall be guilty of perjury. So it has to be a statement and it has to be material. Now, a statement is defined as something which is not an implicature. It has to be explicitly said, and it's also in the jury instructions. But the notion of materiality in the jury instructions is very vaguely defined. So the jury instructions only say that material means something which has a natural tendency to influence the decision of the relevant authority. So a very, very vague definition. So will this full concept of a lie influence perjury ascription and potentially lead to an overcriminalization of perjury? Well, let's check with an experiment. This is where this experimental jurisprudence project can help. So I'm going to use in the experiment an implicature, so a suggestion very similar to the Bronston case. So if you hear that some of the devices are unnecessary, you understand that usually as some but not all of the devices are unnecessary. But this but not all part of some is only an implicature, a suggestion. It's not part of the semantics of the word some, because if you embed it under a conditional, so if you say if some of the devices are unnecessary, the employee will be fired. Well, then you understand it that if all of the devices are unnecessary, then he will also be fired. Otherwise, it wouldn't really make sense to fire the employee if some of the devices are unnecessary, but if all of them are, to keep the employee would be sort of unnatural. So the meaning of some is if at least some of the devices are necessary, the employee will be fired. The meaning of some, if it is at least some, and the some but not all part of the meaning of some is an implicature, a suggestion. And I'm going to use a real life case, a very famous case of US represented by Jeffrey Bierman versus Orthofix International. So Orthofix was a company producing medical equipment, and they were producing medical equipment which is extremely rarely needed. So they were producing some bone growth stimulation devices. These are devices which are very rarely needed, and they're supposed to heal bone fractures more quickly. And the employees of this company trained physicians to recommend to patients to buy these devices and use these devices for a long treatment. And the patients claimed a refund from Medicare, and Medicare refunded Orthofix. And this way, Orthofix earned a lot of money for medical devices which are extremely rarely needed. And of course, the case went to court for fraud, and the court stated that, well, the number of devices necessary for patients, since they were sold at a flat rate, so they always had the same price, is material to the case. It's a material lie because the number of devices is important to say what the sum of fraud was. But the length of prescribed treatment is an immaterial lie because it doesn't matter how long the patients used the devices for determining the sum of fraud, right? It doesn't matter if they used them for short treatment or long treatment. It did not impact the sum of fraud, and the court in these proceedings had to define what the sum of fraud was. And so the hypothesis is that in such cases where the law says, okay, perjury has to be a material statement. So if it's a material implicature, like Bronston, there should be no perjury. And if it's an immaterial statement or immaterial implicature, then also someone should not be convicted for perjury. But my hypothesis is that the folk ascriptions will be different. So since the folk concept of a lie is broader than this legal concept of perjury, people will judge all these 4 types of statements and suggestions or implicatures as being perjuries, as being a lie in the courtroom. So let's check it. So I built a scenario based on the case I just described. So there were 5 bone growth stimulation devices on the table, and I told participants of the online study that there's a high probability that all of them are unnecessary. And there is a doctor who is being questioned under oath in the courtroom, and he had a motive to lie. So I explained that this company that produced this devices paid and trained the doctor and so on. And he said, well, some of the devices are unnecessary. And I asked people, so how much trust would they ascribe to this utterance? And then I said, well, look, it turns out that all of them were unnecessary. So was it a lie? I also asked people whether this utterance was misleading, because I thought, okay, perhaps if they have the chance to rate it as misleading, then the lying ratings will decrease. How committed is the doctor to what he is saying? How likely to deny later is he? So can he deny later that he wanted to suggest that not all of them are unnecessary? Does he have a duty to tell the truth, and how much blame could we ascribe to the protagonist for his behavior? And then, so people had the chance to like discharge their moral outrage and their moral responsibility ascriptions in all of these questions, which were asked in a randomized order. And then in the end, I presented participants with the jury instructions on perjury. So I presented them with what a jury would see, the definition which says that, well, perjury is giving a false answer in court, which one knows to be false, and that has a natural tendency to influence the decision of the relevant authority. And I asked them, so is it perjury? Was this utterance of the doctor perjury? And so here are the results. So what you can see here are the mean answers of participants. They're on a 1 to 7 Likert scale. So the midpoint is 4, right? Everything which is below 4, it means that it was not a lie. And if it's above 4, significantly above 4, then it means that people think this is a lie. And I had a control condition where I presented people with a statement, an explicit statement. Not all of the devices were necessary. And then people judged confidently that it's a lie. So the mean answer was way above 5, and it was significantly different from the midpoint 4. So people judged it as a lie. And then I asked another group about the implicature, so about the statement, some of the devices were unnecessary, and they also judged it to be a lie. So it was also significantly different from the midpoint 4. The answers were above 5, and they were not significantly different from the mean answers on the statement condition. So it doesn't matter whether the doctor said a statement or implicature, people thought that this was a lie. Same for misleading ascriptions. So they thought that both the statement and the implicature was, the suggestion was misleading behavior, and that did not lower their lying judgments. And then I asked about perjury. So if it was a statement, of course, they rated it as perjury, but same for the suggestion, right? So the suggestion was also judged to be perjury, and it was also significantly different from the midpoint 4. So this is what we've seen so far, right? That both a material statement and a material implicature is judged by people to be perjury, even though only the material statement, according to the law, should be judged to be a lie in the courtroom, so to be perjury. And then I presented another group of online participants with exactly the same experiment, except that I switched one thing. So the doctor said something immaterial to the case, right? So he said, some of the treatments are too long. And I asked the same questions and observed the answers. And here are the results. So for the lying ascriptions, here you can see what you have already seen. So for the material statement and implicature. Now for the immaterial conditions, for the statement, again, people judged it to be a lie. It was significantly different from the midpoint 4 answer, and same for the implicature, right? So an immaterial implicature was judged to be just as much a lie as a material statement. And I checked, so what is the thing that best predicts what a jury will call a lie in the courtroom? Is it commitment? Is it deniability? Is it trust? Is it blame? Or is it duty to tell the truth? And so the answers were correlated with all of these measures, but what best predicted what people would call a lie were blame and duty ascriptions. Same for misleading ascriptions. So also immaterial statements and implicature were judged to be just as much misleading as the material conditions. And same for perjury. So people would convict the protagonist even for an immaterial implicature, as this was significantly different from the midpoint 4, even though this is not in accordance with the legal definition of perjury. So the experimental results seem to be in accordance with the hypothesis that there is this overcriminalization of perjury because people rule in accordance with the full concept of a lie rather than the legal definition of perjury. And the correlations for perjury were the same as the correlations for lying. So the same measures best predicted what people would call a perjurious statement. It was also blame and the duty to tell the truth. And interestingly, the blame ascriptions in all of the 4 conditions, so all 4 groups of people and the variations of utterance types, were the same, were very high. So blame ascriptions were very high in all of the 4 conditions. So participants blamed the protagonist for for uttering these utterances in the courtroom. So the modest conclusions for the moment are that perjury ascriptions in the courtroom are somewhat inconsistent with the legal definition of a lie. So they follow the full concept of a lie rather than the legal definition of a lie in courtrooms of perjury. And this materiality determination are distorted by blame ascription. So what at least could be done, it could be that the jury instructions on perjury could be a little bit reformulated to explain better to people what is this materiality notion, why do we need it, and also what are the reasons for making this perjury definition so narrow in the law, that there are good ethical reasons for it. So if you are interested about hearing more on the topic, I have a couple of publications on it. Many thanks for your kind attention, and I would be super happy to answer any questions you may have.
Thank you very much, Isa. Now is time for discussion. So I give a floor to our participants. Does anyone have questions? Until we are waiting for some questions, I would like to ask you about, like, do you think that the results, here's Julieta, finish mine, then you can Isa answer, and then Julieta can ask. So do you think that results will be much different if the participants of this experiment were lawyers, like judges? So maybe I would be interested to know whether, despite their like legal education and legal knowledge about perjury, is it affected by their like folk notion of lying? So can they distinguish perjury from lying in like real life outside the courtroom?
Many thanks. This is an absolutely wonderful question, and I'm also wondering about that. So I'm trying to do some studies on that. And I'm a little bit worried. I mean, they should be, right? And legal training should prepare us to be able to distinguish between those two things. But there's so many other studies that you can check out which show that sometimes experts are also biased, or answer very quickly without reflection, or simply sort of reason in a similar manner as lay people. They think, this guy is lying a lot, even if he's not lying about material matters. Well, he's sort of a bad person, right? He's lying to us, and therefore we should convict him for perjury. And the thing is, well, for instance, in the Bronston case, Bronston was surely responsible for like some tax issues or something, but not perjury, right? So there might be like a risk of overcriminalizing here through reasoning about what type of a person this defendant is, rather than looking at what really is at stake in this case. So I think it's a super interesting project for future inquiry, and I would be like happy to collaborate on some like cross-cultural also verification of what experts would think in civil law countries on that. So many thanks for the question.
You're welcome. Julieta, floor is yours.
Well, first of all, thank you very much for your exposition. I found it really, really, really interesting. One of my questions was somewhat similar to the question of Mila's. So if the results would be different if we were considering some kind of experts, maybe not lawyers, but professors in a wide sense, or also maybe people from, I don't know, scientific environments, trying to make the distinction, but that was already answered. My second question was about that maybe you could tell us a little more about these blame ascriptions and these duty to tell ascriptions, because I found it really interesting that you were trying also to correlate these ascriptions to the possibility to predict whether they were going to ascribe also the etiquette of perjury to something. So thank you very much.
Many thanks. It's a great question. Yeah, I mean there might be many factors that decide on this blame and duty to tell the truth. Here it's a specific situation. I mean I did the experiment based on a real case, right? But it's true that it's a doctor, so people may consider, like, for instance, medical people, like, as having more of a duty to tell the truth than other people and so on. But I also did experiments where the protagonist was an accountant, so had nothing to do with like medical training and so on. And the results on lying were sort of similar. So I guess that's an interesting future project to see how it works, and also to see how we could potentially block this blaming inferences, right? So try to make people decide less based on their emotions, moral emotions, and more on some sort of rational deliberation about whether someone fulfills this criteria for perjury or not. And of course, this is like, I'm only giving one example of my study on perjury, but there's like many studies in experimental jurisprudence pertaining to other notions in the law, which have a similar mechanism, right? So intention, causation, negligence, all sorts of mental states, consent, and I'm sure I'm forgetting many other notions which are being tested, and where the similar interesting pattern is being present.
Now we give the floor to Boyan.
Thank you, Isa, for a wonderful presentation. To put my cards on the table, I'm absolutely fascinated by both experimental philosophy and experimental jurisprudence. My thing is always like, you're doing the thing that I know I'm never going to do, kind of to learn, to get into the nooks and crannies of this research design and the methodology of empirical research and stuff like that. That's why I'm hoping that Mila mostly will do most of this work on the faculty, and that I'll continue like dealing with speculation most of the time. I will ask you. I kind of figured that
continue
you
to stay in this chair which is burning. That's your idea.
Which what?
To stay in this chair which was burning on the first slide.
Absolutely. Absolutely. So this is kind of like, for a long time we had this idea in jurisprudence that somehow jurisprudence should be naturalized, and I know that like we're reading the same people like Dan Priel, Brian Leiter, Brian Tamanaha, and stuff like that, and no one really got into this thing that you are really deep into now for several years, right after the book on pragmatics, linguistic pragmatics. And a lot of stuff is happening, but I'm not seeing, of course, when we all do our little conferences, we all know what the others are doing, but I don't see results of experimental jurisprudence propagating much outside of these little fascinating clinics in various universities. Like obviously Krakow is one of them, but there's one in Switzerland and places like this. Could you please enumerate the things that you consider the main findings from the perspective of classical jurisprudence, or those results in experimental jurisprudence that fascinated you most, either yours or other people's, when you compare it to these intuitions that we had or that we usually have collectively in classical jurisprudence?
Yeah, many things. This is a great question. So first of all, I would like just to emphasize that like experimental jurisprudence does not aim at like replacing conceptual analysis or speculation, or like, I don't know, the need to think about what the law should be, right? So what normative criteria we should have. Absolutely not. Like, this is a way of supplementing this this thinking. And I think like So it's going to be difficult to like enumerate all of them because there's so many, but I just can give a couple of examples, and I'm sorry if I forget something important, but like just thinking on the top of my head now. So one, I guess, big inquiry, which is super interesting, is about, okay, so what do people think about the law, and even like about the concept of law? So what, I don't know, like platitudes exactly do they hold about the law? What is their concept of law? Is this concept consistent? Do they have like some sort of inconsistencies in thinking about that? If they have inconsistencies, why these inconsistencies? Like, can that be a danger, for instance, for implementing our normative theories? So can it be so that our psychology makes it more difficult for us to implement some fair normative rules? And okay, so a lot of research on that. I'm just going to name a few people, but I'm sure there's more. So there's like Ivar Hanikainen and Guillermo d'Almeida and Noel Struchiner, and a bunch of people working on this. Also, Joshua Knoop. The second like big finding, and I think it's super interesting, is about biases in adjudication, especially like connected to criminal law. So we have like some criminal law principles, and like I've really compared criminal legal codes like in civil law and common law in many countries around the world, and there's really like many similarities in the sense that they're all very much focused on mental states, right? So people should be generally like judged with what risk they create and the mental state they have, and not about the consequences of their actions, which consequences can be like a matter of luck, right? So they can be lucky, unlucky, and so on. And like people tend to, in the courtroom, look more at the consequences, which elicit some sort of emotions, like blaming emotions and so on. And then they convict more harshly the unlucky people, even though they had, like, for instance, the same mental state and risk as the lucky ones. And so this is, for instance, a big strand of research by my colleague from the University of Zurich, Marcus Gner. So like the main person in the Guilty Minds lab. But also Edouard Machery, for instance, does a lot of work on this, and Sacha Bourgeois-Gironde in France, and so on. So there's also a lot of research on that, and I'm sure I'm forgetting many more people that are working on it. Then another big strand of research connected to criminal law, but not only. So also it impacts tort law and civil law and contract law, is causation. So we have like these rules of ascribing causation, right? So who caused what? Can we say that the consequence was caused by X? And again, here, like there's a lot of research showing that people do not stick to the principles they preset, right? So they're also guided by emotions, by some irrational thinking, and so on. And for instance, James McLeod has a lot of interesting research on causation. Also Kevin Tobaya, also Levin Guver. I mean, like there's so many people, I probably wouldn't be able to like list all of them now. And then another big strand of experimental jurisprudence research, which has a lot of interesting things to say about old jurisprudential questions. So this is this research on legal interpretation proper. It's like, how do we process legal rules and then try to figure out their meaning? And so is it the case that we think like, okay, what does this mean? And then we find all these arguments for what it can mean, and then we decide on the basis of some, principles of interpretation what the meaning was. Or is it sometimes a little bit the other way around? So we already have like a hunch, and then we, try to justify that hunch. And another interesting strand of research here is also how does like moral reasoning impact legal reasoning? So are we able to like distinguish between the two, or is it more like it's such like some sort of like subliminal impact on our reasoning? And again, there's a lot of people working on this, and for instance, I don't know, like also Jeremy and Meda, but also my colleague from Fribourg in Switzerland, so Benedict Perker. And like I'm sure I'm sorry, I'm just like, you know, giving you a few names, but there's more, right? There's a lot more on this. And then also like the concept of consent. So what does it mean to consent to a contract and so on? A lot of research by Rosianna Sommers and so on. So finding that sometimes people find that there was consent, but there was not one legally, or the other way around, there was one legally, but people think it's not, you know, like the folk notion of consent. And there's also like wonderful corpus linguistic studies. So people who try to provide new arguments in this originalism versus living constitution debate, or originalism versus textualism and purposivism debate, by looking at different corpuses of language, even original corpuses from like the I don't know 18th century and so on, and trying to look if these are like psychologically plausible theories. So like I see it as giving a good basis for us to do some normative thinking, you know, based on what people really think and like what they psychologically really do. We can see like what are the psychological limitations, what are the dangers, the biases, and then based on that we can do conceptual analysis and some normative building of like what would be the best definition of something we would think of, or something like that. But I think if you start this like normative thinking on the basis of experimental jurisprudence studies, you are likely to get much more effective and fair results than if you just, you know, you don't check, you just think, okay, that would be a great idea, but like I don't know if it's gonna be psychologically apt for people to use it and so on. But sure, like it's not a project which will replace, right? It can all. This is like an important supplement, I think, of what we're doing in jurisprudence. I don't know if I answered your question. I mean, it's just like a couple of examples I've been thinking of, but there's many more. And there's many more people working on that all over the world, basically.
Okay, now we have time for 2 more questions. So Professor Nina Kršljanin is the first one, and then Julieta figure out that she has one more. So the second one is Julieta, and then maybe you can answer both of the questions in the same time. But Julieta is now gone. No, I see her elbow. Yeah, okay. Okay, so Professor Kršljanin, floor is yours, then Julieta.
Thank you. Thank you for a very interesting lecture. I'm not from the area myself, so it's very interesting to hear. And I was curious, given the legal definitions of perjury, you gave the example of the US one, but we can, I presume, generally agree that most legal definitions of perjury differ from the folk concept of lying. Even leaving immateriality aside, we can justify that to a common person by saying, okay, yes, he did lie, but he didn't lie over an important matter, so that's immaterial. That's why he won't be punished. But the very definition of perjury, in keeping that in mind, do you think it's a good thing that it's different from the common person's perception of lying? If yes, what's the good thing about it? If no, why do you think it persists?
I think this is a wonderful question. Yeah, because some people could say, well, maybe it's just that our legal definition is just too narrow, right? Let's make a broader legal definition so that it fits the folk concept. Maybe the folk is right? That we should punish more for perjury, so also suggestions and stuff like that. But I still would argue that it's good that this definition is narrow. Even if there might be like some clever, people who would like use it to escape perjury conviction or something, I think still that these cases are relatively rare. So it's like a rarity that people would like exploit it, right, in a wrong way. Most people just arrive in the courtroom for the first time in their life. They're pretty much stressed, and they're just trying to give an adequate account of what they saw or what they heard, and they often don't know what is material, what is not material in the case, because they have no legal training. So I really think we should shift the burden of getting the truth out of the witness on the lawyer, rather than putting the burden on the defendant, which sometimes maybe is clever and is trying to exploit the legal system, but most often he's just sort of lost. And it would be kind of unfair to for instance, hold him responsible for suggestions that he might not have been able to foresee or something like that. So I would be more leaning toward the idea to leave this narrow technical definition and like change jury instructions or train lawyers more to properly question the witnesses and so on, rather than use this or rather than broaden this definition of perjury in the way that people answer, because maybe it's more guided by emotion than rational analysis of the situation. Does that answer your question? Is that helpful?
Yes, thank you very much.
Since we're trying to fit into 1 hour frame for this lecture, Julieta just decided to write email about her question, and she's giving a floor to Miodrag. So, Professor Ivanovic, the floor is yours.
Thank you very much. I'm thinking about it. It was a really brilliant case study that you presented. I'm just thinking whether you call it a little bit different than the rest of the experimental jurisprudence, because I don't pretend that I have read much in the subject area, but my hunch is that most of the studies in this area try to show us that probably there is something wrong with most of the legal concepts that we operate with, starting from the concept of law. Whereas you show us in this, your case study, completely different thing. You show us that in the very specific situation where a layperson, folk understanding of a certain legal concept basically does not match the proper understanding or proper meaning of the concept of lying. So in that respect, I'm just interested whether it's in a way different than the rest of the scholarship, and what, in your opinion, because you mentioned a couple of times this supplementary nature of the experimental jurisprudence, what is your general estimate to what extent can be findings of experimental jurisprudence be of use for law, for lawyers, or for changing the content of certain legal concepts? Because it is obvious that law in principle is not, neither law nor lawyers are obliged to follow the findings even of a hardcore science, if you put it that way.
Okay, yeah, many thanks for this question. So I think it could be, so maybe let me start with the last part of the question. I think it could be very useful, for instance, in making sure that the training in law schools is like the best training we can do, the best possible training we can do to really make people later follow the law, not be biased in legal decision making, and to be able to like apply the legal normative concepts in a fair way. But perhaps it could also sometimes be helpful for the legal definitions, in the sense that if we see that some legal definition is really not understandable, or like psychologically it's very difficult to grasp, then we can sort of reformulate it. So in that sense, I think it can have a big impact in all legal fields. So not only criminal law, but also other fields of inquiry. And then the first part of the question is super interesting. So is it that we analyze the legal concept, or rather the folk concept, and then we see if it matches the legal one or not? I think there's a lot of studies that analyze the folk concept of law, but there's also a lot of studies that really focus on the discrepancy between the law and what the folk thinks, assuming that what the law says is the rational part, and then analyzing this, let's say, departing from this concept. So, for instance, the legal lack studies that I did with Marcus Kneer, but he has more studies on that, so he could say more about it, that generally like a criminal law code is based on mental states, right? But people tend to be very consequentialist, so they tend to punish more for bad consequences rather than for good consequences, even if both protagonists, so one that produced the bad consequences and the other that produced the good consequences, had the same mental state, took the same risk, same decision, and so on and so forth. So in that sense, it's not only my study that shows that people dangerously depart from what the law says, but there's more studies that can show us where we should be more careful, maybe, in order to be fair in our adjudication. So I think there's a lot of projects in experimental jurisprudence, and some are focused on investigating this discrepancy between the folk concept and the legal concept, and others are investigating, for instance, what people think about the law or so on. Is that a helpful answer? Or okay, thank you for the question.
Isa, so thank you very much for the lecture. It was our great honor to have you here, and I hope that this lecture is just the beginning of development of experimental jurisprudence in Serbia or in Balkan. Yeah, so
thank you so much for the invitation.
Okay, thank you very much, and I hope to see you soon.
Bye. Thank you so much, Iz. Hopefully we'll get you in Belgrade soon enough.
That would be great.
I hope by the end of the year, and we have this great part of the